I'm here today with Randy Long, and we're going to talk a little bit about wills and trust, what's the difference, why people need one, and why so many people don't seem to have one.
Well, let's start with why people don't seem to have one, Bob.
Okay.
And in my experience after years of doing this, it's because all too many people just think it hastens their death.
Oh, wow.
Or they think they don't have anything. And it's one of those things that we put off and we put off. Matter of fact, I'm used to asking a client, when are you leaving on your trip? Because it seems like people get ready to go on a trip. Oh, I'm going overseas or on a long trip. I need to get a will or a trust done. So I think that's the reasoning behind that. But everybody needs an estate plan because if you die without a will or a trust, Oklahoma law is going to distribute your property for you under a set of laws called the intestacy laws. Testate means with a will, intestate means without a will.
Okay.
So the law wants everybody's property to go to family, and so state law will dictate it, but I tell clients it's a one-size-fits-all. You don't have any discretion. You don't get to make some of the choices you can make in a will or trust. So there is that fallback provision, but wills aren't that expensive. Trusts are a little bit more expensive, and I'll explain the reason for that.
Okay.
Because I tell everybody that a will or a trust is just a different vehicle that goes to the same place.
Okay.
And you can get there by driving your will, so to speak, or by taking your trust. They just do it a little bit differently. A will is tried and true. They've been around for centuries. You can prepare a will and you can basically forget about it because it does not impact what you do with your property while you're living. It only comes into legal force and effect when you die. So you leave the bulk of the work to the person you name to carry out your will. We call that person a personal representative. So the bulk of the work comes after you're gone. The cost of a will is not, again, in most instances, unless you're doing things unusual or complicated, like I said, is not that expensive. Trust, on the other hand, is a different animal because you're creating the trust, and the best thing I can analogize it to, it's like forming a little corporation or a little limited liability company. The trust comes into being when you create it, and it only governs what it owns.
Okay.
So if you want your trust to dictate where your house, your lake property, your investment property, your stocks, whatever you want the trust to govern, it has to own. So you deed houses and real estate from yourself to yourself as trustee of your trust. You put your bank accounts in the trust name. You title your vehicles. Whatever it is, it has to be owned by the trust. So there's a little bit more work involved in setting up a trust that governs from now. In an estate planning trust, usually people do a revocable, which means you reserve the right to change it. Irrevocable means you can't change it. So most people making an estate planning trust in lieu of a will will make it revocable, so as things change, they can make changes to it. Then when they're gone, then it becomes irrevocable because then they don't want anyone changing it after they're gone. So that's kind of in a nutshell the difference between the two.
So on a trust, that you own the trust, but when you die, who owns the trust?
Well, technically, I guess you still own it, but during your life, you normally name yourself as the trustee of a revocable trust. So you don't have to deal with your property differently. We've just got it in your trust, and you can go on about your business. Then you normally name a successor trustee, so that if you become incapacitated, unable to function, then that successor trustee takes over, and they're guided by the terms of the trust. They have to follow the trust terms, so you've already set forth, here's how I want. And most estate planning trusts provide that the trustees are to provide for the trustor, the settlor, the person making the trust during their lifetimes. Mm-hmm. Then once they're gone, then here's where it goes, just like maybe a will would do. pay my bills, wind up my affairs, and then I want this asset to go to that person, or I want it divided equally between certain persons.
Okay, so getting back to wills a little bit, you say there's like an executor of the will, or is that the term you use?
I use personal representative.
Personal representative.
But the term you used is proper. Executor, we have executor, executrix. This goes back to times when the difference in the sexes meant more. We referred to men differently than women. So if it was a man and there was a will, it's an executor. If it was a woman and a will, it's executrix. If it's no will, we're just administrating the estate under the laws of intestacy, then it's a testator is a man, testatrix is a woman.
Oh, wow.
Then as we get a little bit into more modern times, we replace those with personal representatives. So whether it's any of those, whether it's a will or not, now it's personal representative.
Okay. And how important is that, choosing the right personal representative, I guess?
I think it's very important. To me, it's the linchpin to all of your estate planning, because it doesn't matter how strong, how detailed we write a will or a trust. It's only as good, in my opinion, as the person we've designated to carry that out.
Okay. And if they die without a will, does the judge appoint a representative then, and he can just basically do what he wants to with this stuff?
So Oklahoma law sets forth the priority for people to be personal representative. And the person you name in your will is the first priority.
Okay.
Your spouse is second, and then it goes, I believe, to children, and there's a whole litany. So if you don't have a will and haven't designated that personal representative, then we're going to look to that state law and we're going to see who wants to do it and in what order. So if your spouse wants to do it, your surviving spouse, but a child wants to do it, well, if the spouse qualifies, then they have a priority to be appointed, and they're going to get appointed.
Okay, and so would you say that there's more litigation involved when they die without a will and there's property to be dispersed, or could it be either way? With a will or without a will, you may have litigation?
Yes, I, of course, haven't kept track of that over my career, but I would speculate that there would probably be more without a will, although the majority of wills go through without a hitch. Okay. But there is a significant amount of litigation, because when the person that made that will is gone, they're no longer here to tell us this is what I meant. Mm-hmm. And I found that once mom and dad are gone, children sometimes see it differently.
Oh, sure.
People see it differently, and that's where we can get into litigation.
We see things differently a lot of times from the point of time that we're looking at it also.
Absolutely.
So the person that's making the will, the more clear and precise and detailed they can be about what they want things to happen with their estate, that makes it a little better. And probably the same with the trust.
Sure. Two things in that regard. You want to use an attorney for a will, and I know that's self-serving, but whether it's me or someone else, you need an attorney, because again, we're not going to find out if there's a problem till after you're dead and gone, and then it's too late to fix it. There are holographic wills. You can write out in your own handwriting, date and sign it. It's not witnessed. It doesn't have to be notarized. That's a valid will. But if you write it on hotel stationery and there's a label on that, that can invalidate it if someone signs as a witness. So they're fraught with peril, and I've dealt with several of those over my career, and some of them have worked, but people don't know the name of personal representative. They don't know some of the things they need to address, the power to sell, and it just causes the cost of the probate to be more expensive than it would otherwise be.
I know you talked about people sometimes getting ready to go on vacation, and that's when they say, oh man, I better get my estate in case I die in a car wreck or plane crash or whatever. Do you, I know for my family, it was a health calamity with my mother-in-law, and we didn't have anything in effect, and so then we're scrambling.
Right.
And do you find that most people are scrambling when they call you?
A lot of people are. And the other thing besides going on a trip is I'm getting ready to have surgery.
Oh.
You know, and that's another big thing so I'm used to, And we're in the business to help people and accommodate people. So you learn to ask, do you have an upcoming trip scheduled, or are you going to have surgery, so that we can fit that window, because it is important that it's done right. But even if it's a short term, if it's an attorney that has experience in dealing with it, I'm used to dealing with short time frames. I'm sure my fellow attorneys out there that do any amount of estate planning are used to that as well.
Okay. Randy, we thank you for coming on today and helping us get a little clarity there on wills and trust. And if they have any questions, we've got your number up there on the screen. People can call that number. And I'm sure you guys do a certain amount of free advice over the phone.
Absolutely.
And then when it gets time to really get down to the nuts and bolts, there might be a charge for that. But I'm sure there would be a charge for that. But thank you so much for coming on, and I hope this helps people have a little bit of clarity. And my advice as somebody who's experienced this with their family is don't put it off.
That's the best advice you can give. Thank you for the opportunity.
All right. Thank you, Randy.